We're entering the fourth day of clashes between protesters and the U.S. National Guard on the streets of Los Angeles, with demonstrations centering around immigration raids. President Trump bypassing the state's governor to deploy thousands of National Guard troops. Now, for more on this, we're joined now by constitutional law expert and historian Joshua Kastenberg. So, Joshua, this action by President Trump is being called extraordinary, with some suggesting, he appears to be laying the groundwork to expand the use of the military. California Governor Gavin Newsom, he's calling it unconstitutional. So, Joshua, my question to you is, under what constitutional authority can a president deploy the National Guard to a state without the governor's request?
So the President of the United States is the commander-in-chief over all of the nation's forces. And when the Constitution was written, it assumed that the governor of each state would call the National Guard up if the president declared an injury. But in this particular case, the president has bypassed that assumption. The Constitution does not prohibit President Trump from doing what he's doing, but the assumption again was always the president could only do this if there was a foreign invasion, a complete breakdown in law, or an insurrection. And it doesn't seem to me like any of those three aspects have been met.
So Trump then does have the legal authority in this case to call the National Guard to Los Angeles.
Right. So he's federalizing the National Guard. He has the constitutional authority in those three areas to call the Guard up. But what he's done is he's redefined under the law what a national emergency is. And the last time this happened in American history, in terms of bypassing a governor, you have to go back to President Grover Cleveland in the year 1894, when the Illinois governor specifically explained during this large labor strike called the Pullman strike that he did not want the military brought into the state of Illinois to stop a union work stoppage. And President Cleveland did it anyway. That's the only precedent for doing what Trump is currently doing.
So then how have courts ruled on similar deployments in the past, and what legal standards did they use?
So here's the interesting thing. The courts have ruled that they are not in a position to supervise the command and control of the military. The most recent case comes out of the Kent State massacre during the Vietnam conflict. On the other hand, here are the constitutional aspects that are at play. Trump is the commander-in-chief of the nation's armed forces, but the Constitution gives to every citizen of every state the right to a Republican form of government in each state, and that means a governor who's commander-in-chief over the state's military forces that can operate independently, and it means a state legislature and a state judicial system that are not usurped by the federal government. Then there's the 10th Amendment, which reserves all these police powers to the state. I mean, the Constitution is a restriction on the federal government, and it seems that Trump is expanding, if not breaching, those restrictions here. So what he's really doing is intruding into the province of authorities that belong to Governor Newsom of California. And I'd say one other thing. You can go back to Harry Truman, President Harry Truman, and the seizure of the steel mills during the Korean War, where the Supreme Court specifically articulated, Justice William O. Douglas, that if a president can call the Korean War a national emergency and do what he wants to do, then presidents will routinely make up national emergencies to get their way. And we're living under that warning right now.
So, Joshua, does Governor Newsom have any power to block what's happening? Now, we know just this morning he did announce the state does plan to file a lawsuit against Trump.
No, I mean, his only redress is to go to the federal courts and argue that President Trump has undermined Article 4 of the Constitution, which guarantees to every citizen a Republican form of government, violated the 10th Amendment, and is trampling on the First Amendment rights of California citizens, specifically in Los Angeles, by stoking fear. But again, it would be unusual for the courts to agree with that argument. However, we're living in unusual times. Unlike Kent State University and the student upheavals and the like, we're really dealing with a situation where federal forces went in to conduct lawful detentions, but they did it without coordinating particularly well with the state. and stoked, a tinderbox, and that makes this situation unusual.
So, Joshua, then how does the Constitution balance federal powers with state sovereignty in cases like what we're seeing in California?
Well, this is something the framers of the Constitution specifically warned about. They did not want another Oliver Cromwell. They created the Constitution around the concept of fear of executive power and fear of standing armies. And what the federalization of the National Guard has done is created a larger standing army. This is a standing army that can affect the political rights of citizens living in Los Angeles, like I said, to have a Republican form of government. John Adams and Thomas Jefferson and others who were influential in the shaping of the Constitution were very well aware and fearful of the type of authority that dictators like Oliver Cromwell had used in terms of shutting Parliament down to get their way. And so they created all of these safeguards in the Constitution. Those safeguards now are being pressured, and there's a threat of breaking those safeguards under this situation, which could have been easily avoidable.
All right, Joshua, always lots to talk about here. We'll leave it there for now, but thank you so much for your time and your insights today.
Thank you.
That is constitutional law expert and historian Joshua Kastenberg.